welcome. I'm going to call the first case, which is a Markiewicz versus Markiewicz. It's a oral argument on the application, 15 minutes per side. Each of you will have a 2-minute fire-free zone. And you can start when you're ready. If you're going to reserve any time for rebuttal, we just ask that you keep track of it. Try and keep track of it yourself. But feel free to start.
Good morning, Your Honors. My name is Nick Curcio, and I'm appearing on behalf of Appellate Sarah Markiewicz. Thank you, Madam Chief Justice, and may it please the Court. The desire to bring a child into this world is a deeply human aspiration. Many achieve that aspiration without difficulty, but for others, the path to parenthood is long and arduous and can test the limits of hope. Michigan voters recognized that fact when, in 2022, they enshrined fertility care as a fundamental right under our Constitution. In doing so, voters sought to restore hope to the thousands of Michigan citizens who struggle with infertility and who could benefit from new reproductive technologies like in vitro fertilization. This case presents the Court with its first opportunity to effectuate that right. It does so in the messy context of divorce, where a divorcing wife wishes to complete her family by implanting an existing embryo and carrying it to term, while her husband wishes to destroy that embryo to avoid the emotional difficulties associated with emotional discomfort associated with genetic parenthood. While these are both interests that deserve this Court's consideration, we believe the balance tilts heavily in favor of Sarah, who is committed to raising this child from infancy into adulthood with all the emotional sacrifice, physical, financial sacrifice that entails. I'm happy to discuss any of the factors that courts typically consider when deciding these cases, but I'd like to focus today on two that we believe are dispositive. The first of those is whether the disputed embryo represents the last reasonable opportunity for the parent seeking parenthood to achieve it. And then the second is whether that party would be solely financially and otherwise responsible for the resulting child. Where the answer to both of those questions is yes, we would ask the Court to adopt a straightforward test that the party seeking parenthood should prevail. And we believe that any other result would create an unjust presumption in favor of against the creation of new life. It would also undermine the intent of voters to protect and empower those who struggle with infertility.
So you don't have any problems with application of the test that was applied previously in this case, what I refer to as the Markiewicz 1 test?
Yes, Your Honor. We believe
and you've identified two of the factors. Are we to weigh them all equally? Are there factors that should be weighed more heavily than others? And if so, how do we come to that determination? And is it consistent of what we say? These are the most important factors, although you're to consider them all, or do they change from case to case?
So we believe that all the factors should be considered, that being the Sparks factors. We think those are kind of appropriately reduced down to 6 factors in the specific case of embryos, and those being the 6 factors that we call the Rooks factors in our brief. Of those, we do believe that the two most important are the ones I mentioned, that being the reasonable opportunity to achieve parenthood by other means, as well as whether the parent will be solely responsible for the child.
And should that factor on achieving parenthood by other means, should that be weighed more heavily if the person invoking it is not a parent at all, as opposed to someone who has children and seeks more?
We do not believe so, Your Honor. And there's a number of cases that have addressed that issue. The Rooks case out of Colorado is one I recall from the briefing, and we believe that's the correct analysis. With each child, the interest in achieving parenthood, we believe is the same. It doesn't diminish based on the number of children. Especially, we have to keep into account that these are existing embryos, and that sometimes the asserted interest in this case is to bring the specific embryo into this world, which was why it was originally created. So we believe that's the appropriate analysis. We do believe that the Court should consider all the factors, and we think that as we mentioned in our brief, 5 of those, the 6, what we call Rook factors, we believe favor us in this case, and the other being neutral, that being manipulating the court proceedings by claiming the embryo, essentially. We don't believe either party is acting in bad faith in their positions here, so we believe that sixth factor is neutral, but the others support our position for the reasons stated in our brief. With that, I'd like to turn to the reasonable opportunity factor, and I'd like to make...
Counsel,
yes.
if I could just follow up on that. For those two factors, can you point us to any other states that have weighed those in the way you're suggesting is appropriate, or is this something sort of a novel interpretation of the Brooks factors?
Again, we do believe all 5 factors favor us. We would highlight those as being particularly important. One of the articles that we cited in our briefs talk about how the reasonable opportunity factor appears to be just statistically the most important. When that is favoring the party seeking parenthood, the party seeking parenthood tends to prevail, just in terms of kind of looking at the statistics. We think that's appropriate, especially where Michigan has recognized this constitutional right to infertility care. We believe that prioritizing that factor really helps to effectuate that right. And then in terms of the factor of responsibility for the child, we believe that's important because it mitigates any harms on the other end, where one parent is willing and able to financially provide for the child, and where the law of that state allows her to do so, which we believe the law of Michigan does for the reasons set forth in our brief. That mitigates the harms on the other side and tips the balance in favor of allowing that parent to seek parenthood.
Counsel, it seems though other states that have looked at this have mostly seemed to find that the party seeking to avoid procreation should prevail once they balance all the factors. I think it was Massachusetts talked about forced procreation is not amenable to judicial enforcement. Why is that incorrect?
Well, we would point to a kind of recent judicial trend in weighing these cases in favor of the other side. We do think that trend has merit. We think that historically the courts have undervalued the woman's interest, the party seeking parenthood's interest in overcoming infertility and in achieving parenthood. We'd also, as we've argued in our brief, don't believe this should be looked at as as implicating the procreational rights of a parent seeking to avoid parenthood. The procreation has already occurred in these cases. Conception has already occurred. There's no case law outside of this context that recognizes a non-gestational parent's right to terminate pregnancy. If you look at abortion cases, the right to abortion has historically been framed as a right of the gestational parent that derives in part from the fact that the child is in her womb. We don't believe those cases should be extended, as the amici have argued in this case, to encompass a right to avoid parenthood to a non-gestational parent. Proceeding to the reasonable opportunity factor, I'd like to make 3 points. The first is that the trial court here did not make a specific finding that Ms. Markiewicz had other reasonable opportunities to pursue parenthood. I'd point the court to page 152 of the appendix, where the trial court discusses its findings and it discusses this factor. We think that at most, the trial court's comments can be read as a finding that it was medically possible for Ms. Markiewicz at her age to carry an embryo to term if there were one available and if it were implanted. We don't think that it's a specific finding as to reasonableness. Even if it were, we think reasonableness is a question of law, and that this court wouldn't be bound to a clear error standard on that factor. The second point we'd like to make as to reasonable opportunity, we believe the appropriate analysis is that the court has to look at the specific interest being asserted. Some of the literature that we cited in our brief talks about parenthood as a bundle of sticks, similar to what we talk about in the property context, with that consisting of 3 interests, being the interest in gestational parenthood, the interest in genetic parenthood, and then the interest in legal parenthood. Ms. Markiewicz is seeking all of those interests, and as a result, we don't believe that it would be reasonable. The appropriate question is whether it's reasonable to deprive her of any of those interests. And for that reason, we don't believe that adoption is an appropriate alternative, which the court in Markiewicz 1 also indicated, citing some cases like the Rooks case out of Colorado as well as the Jocelyn P. case from Maryland. And we also don't believe that that adoption or even embryo adoption from another donor fully satisfies the interest because of the interest in genetic parenthood. And finally, on this point, we would ask the court to take consideration of the significant financial cost of restarting the IVF process. The record here indicates that the restarting would cost at least $15,000 at the time of the hearing. That was over a third of Ms. Markiewicz's income, and we believe that's materially unreasonable given the fact that the embryo already exists and there's evidence in the record that costs for implanting that embryo would be largely covered by what's already been paid. Moving to the second factor that we think the court should really favor or should strongly consider in this case, that being who would be financially and otherwise responsible for the child. Here I'd like to make 2 points as we did in our brief. First, we think the Assisted Reproduction and Surrogacy Act of 2024, which I'm going to refer to as the ARSPA, covers this issue. It lays out a statutory framework that defines donor in such a way that it includes both married and unmarried persons who contribute sperm to the IVF process. And then it provides 3 very specific pathways for those individuals to assert to assume parental rights or parental responsibilities. And we don't believe that any of those has been pursued in this case. The first is an express agreement to parent the child together. There's no evidence of such an agreement in the record. We don't believe that one exists. The second is to have your name placed on the birth certificate at the time of birth. We don't believe that would occur here given the circumstances. And the third is a court proceeding seeking a declaration of paternity. Mr. Markiewicz would not have to pursue that if he chose not to.
So is it your position it's a straightforward application of that statute to hold that the father, in this case Mr. Markiewicz, and the father of the other children from conceived through IVF would qualify as a donor? Does that mean that any genetic father could always qualify as a donor, or are we stretching the statute to find that this acknowledged father of this is a donor?
We believe that any genetic father qualifies as a donor until they go through one of the 3 specific pathways laid out in the statute to assume parentage. I think that's the intention. That was the intention of the legislature in laying out the act. The language of the act, we believe, is very clear on that point. If the court has
Do you think that the act was intended to cover a situation like this?
I think that the act was intended to be the sole mechanism by which parentage is determined in assisted reproductive technology cases. And I think that's important because the family law section has cited a now repealed section of the public health code that they believe controls. We strongly disagree with that. That section was repealed by the ARSPA. We believe that the intention of that repeal was to direct all decisions relating to parentage in these reproductive technology situations to the language of the ARSPA, and that the definition of donor plus the 3 pathways are what should control. If this court disagrees, or if this court prefers not to reach that issue in this case, given that it's not directly presented, we do think there's another pathway here to finding that Ms. Markiewicz would be solely responsible for the child, and that is to just have it entered into the judgment almost like by consent of the parties. The trial court assumed that could be done. We believe that can be done. There is case law in other contexts about agreements regarding child support being disfavored, but we think the unique circumstances related to assisted reproductive technologies and a embryo implanted after divorce would weigh in favor of enforcing that type of agreement. I see I have relatively short time. I'd like to reserve the balance.
Absolutely.
Thank you.
Good morning. May it please the court, Trish Haas appearing on behalf of the appellee, David Markiewicz, and my co-counsel is here this morning, my partner, Don Prokopek. I'd like to start off with addressing the fact that appellant has designated my client's decision to not procreate as one that is selfish. That is the furthest from the truth. His decision is not selfish. The reality is that these parties had 4 children together while they were married. And the reality is that we can't ignore the fact that there are 4 children and assume that father can now somehow be converted to a donor when these children will have, if this child was born of this pre-embryo, we'd have a child that would then be the genetic material of father, but yet potentially their mother is trying to indicate that he wouldn't be a legal father to the child. Nobody is considering the psychological implications of that on that child of such an arrangement. And that is something that the Rooks Court specifically requested or identified should be considered. The other factors should be considered. And here we cannot ignore the fact that there is already an intact family where 4 children have parenting time with their father. The impact not only to the potentially unborn child, but also to the siblings is something that must be considered. And that, other than that, I'd like to point out that for once, we do have an agreement. I think both parties in this case agree that the contract did not adequately identify the disposition of this case. And I think the parties also agree that the Rooks text that was adopted in Markiewicz 1 is the appropriate test. But for the addition that I think there should also be other factors considered, which in this case, the fact should have been considered that there are other children that would potentially be a sibling to the pre-embryo in this matter. Obviously, a case such as the termination of a disposition of a pre-embryo is something that is a factually intensive case or inquiry. The trial court in this matter absolutely conducted the factually intense inquiry that was required and weighed and balanced all the factors. And Justice Zara, to your question, should they be weighed equally? Well, in family law cases, we are aware that the trial court has great latitude in how they weigh various factors, whether it be under the Child Custody Act or the Sparks factors. So I don't think it would be appropriate for any instruction but that the trial court still should have wide discretion in the way it balances the factors. The other thing I'd like to point out is that it is true, Justice Welch, that there are most of the cases recognize that the right to not procreate should always weigh more heavily than the right to create. And that's based in the fundamental constitutional right that identified in Eisenstadt v. Baird, that if the right to privacy means anything, it is the right of the individual, married or single, to be free from unwarranted governmental intrusion into matters so fundamentally affecting a person as the decision whether to bear or beget a child. So to the fact that most jurisdictions recognize that the right to not procreate it supersedes the right to create, I believe that those decisions were correctly decided. Those decisions were made in Davis v. Davis from Tennessee in 1992. The Tennessee Supreme Court recognized that the party wishing to avoid procreation should prevail. Also in McQueen, the court recognized likewise, the Supreme Court of Missouri recognized that the right to not procreate should be weighed more heavily than the right to create. And the reality is that imposing unwanted parenthood on a parent is a serious consideration that cannot be taken lightly.
Counsel, would it make a difference if the embryos here did not include your client's DNA? They had donors from both places. Would that make a difference in the analysis?
I think that perhaps that would make a difference. The reality is in this case, it is my client's genetic material, whereas it is not mother's genetic material, but rather her sister. So I do think that could have yielded a different result. But my client is cogently aware that he's not requesting donation of the embryo like we have in some of the other cases from out of state. He's requesting that it be donated to science or destroyed. He simply doesn't want to be a parent again, but the genetic connection wouldn't be there if there were donated sperm, so the disposition may have been different.
What if all the other siblings had the same genetic makeup? And so he is, obviously dad to the existing children, but not his DNA. They got donors for both. And then same DNA in that final embryo.
I still think the inquiry would be different from the perspective of my client, because insofar that it is his genetic material, he can't cope with the emotional, knowing emotionally that there's a child that would be potentially created with using his genetic material. I think it would be a different feeling, and I'm just answering for him. It's hard for me to answer, but I think the inquiry would be different if it wasn't necessarily his genetic material, because he wouldn't feel that commitment as he feels right now.
And then, in your view, that's something a trial court can make that as part of their analysis?
Absolutely. When I was reading all these decisions from the other courts of the United States last night, I was interested that, I do think that when you look at the case law as a whole, that the way that the courts across the United States have balanced this is very interesting. There are cases in which mothers were favored and the right to implant was upheld, but that was mainly cases in which the parents themselves had recognized that they wanted to create these embryos, and they recognized that as part of their religious beliefs that they had a duty and obligation to bring these embryos, to do the best to bring these embryos to life. So obviously that would be a totally different consideration. Also, there were cases in which it was weighed in the mother's favor because a mother had undergone chemotherapy or was going to go undergo chemotherapy, and because of that her chances of fertility were going to be erased. So that's a different consideration. There's certainly a million different scenarios that we can think of that certainly the discretion must lie within the trial court.
And sort of moral and religious conviction, it sounds like you believe can play a role. Did it here?
It did not play it here because, first of all, it was not addressed or raised in the trial court. And quite frankly, in this matter, the parties had stipulated that they did not consider this pre-embryo to be a human being, but rather marital property. And a lot of the other cases across the United States, the parties had stipulated that they considered this to be their child, even though it was a pre-embryo. And that wasn't the case here because there was a stipulation that it was marital property. So that's why I think, there can't be a bright line rule per se, but I do think that the parent opposing parenthood should have a slight edge, except in the compelling circumstances, like I've mentioned, wherein a parent might lose their ability to procreate due to chemotherapy. Or another case, the McQueen case, the parents were deployed, or dad was deployed, and they wanted to preserve the chance for life despite the fact that he'd be deployed for a year. There are a million different circumstances that should be weighed and considered by the trial court. But it's certainly, and the trial court in this case appropriately weighed the considerations. And I did lose track of time, but I'll be quick. The other thing, with regard to the Surrogate and Reproductive Freedom Act that's just took effect, I think it's important that we can, although perhaps I don't believe it really addresses the issue in this matter, to answer your question earlier, Justice Kavanaugh, but I will say that we should be reading it in pari materia with the Reproductive and Surrogacy Parentage Act. And that act alone recognizes that it's not just the inquiry of the donation. But
you want us to read a constitutional provision in pari materia with the statute?
No, I was talking about the analysis of this case to be read in pari materia with the new statute about Assisted Reproductive Act, not the constitutional amendment.
Gotcha.
I'm sorry for any confusion.
No.
But that act recognizes that it's not just it's a two-pronged process. It's not just the donation or the assistance, but it's also the intent to be a parent. And here my client does not have the intent to be a parent. With regard to the Constitutional Act, I do think that the Court of Appeals correctly decided that the act should not be applied retroactively. There simply is no support in the record for any such construction. The people of the state of Michigan, when they enacted it, did not indicate an intention for it to be applied retroactively. And similarly to when we enact statutes, they're not presumed to be retroactive either.
When you mentioned that the statute is a two-part inquiry, including, or perhaps most importantly, intent, is that intent measured at the time of the creation of the embryo? Is it measured at the time that it's being asserted that the person is now a donor or has rights?
I think the intent must be measured at the time that there's a chance for procreation via the implantation of the pre-embryo. Reason being is simply, even when you look at a contract for IVF, the IVF facility, notwithstanding the fact that the embryos were preserved, still require both parents' consent to implant. So there clearly, in all of these contracts, it was recognition that it was a two-pronged process, not just not just the intent at the time, but the intent when it comes time to actually potentially develop this pre-embryo into a child via implantation. Does anyone have any questions?
Any other questions? Thank you very much.
Thank you.
And I think you have 1 minute and 10 seconds left for rebuttal.
Thank you. I'd like to return to Justice Welch's question about circumstances that could potentially weigh in favor of the parent seeking parenthood. We believe that both the circumstances that were discussed do favor Ms. Markiewicz in this case. The first was moral conviction, and opposing counsel referenced the stipulation that was made in the trial court. That was just a stipulation that a property distribution framework applies in this case. At the time of that hearing, that was somewhat in question under Michigan law. There was a case that previously reached this court called Karunji, where an argument was made that it should be a custody analysis. All that counsel was stipulating to was that the property framework was the correct one. And we have consistently maintained that throughout this case and believe that the Rooks factors are an appropriate implementation of a property distribution and not a custody analysis. The second is whether the fertility has been erased. Ms. Markiewicz is in her mid-40s and is postmenopausal. She hasn't gone through chemotherapy, but I think has just similar chances of achieving parenthood without the use of this embryo. Thank you.
Well done. Thank you. All right, thank you. The case will be submitted.